I want to talk to you about a case that may turn out to be one of the most important tech liability cases of our time. The jury found Meta was negligent in designing or operating Instagram, and that Google was negligent in designing or operating YouTube. Let's dive in. Hi there, and welcome back to Life is Legal, where we unpack the laws that sneak into everyday life without the Latin, the lecture, or the stodgy lawyer vibe. I'm your host, Brooke Hardy, lawyer and legal translator. Today, I want to talk to you about a case that may turn out to be one of the most important tech liability cases of our time, okay? Not because of the dollar amount and not because Meta and Google are suddenly writing enormous checks that are going to send their stock prices spiraling downward or anything. I want to talk to you about it because just days ago, a Los Angeles jury did something that courts and juries had never previously done. It found Meta and Google liable for harms allegedly caused by the addictive design of Instagram and YouTube. And it awarded the plaintiff in that case, a young woman identified publicly as Kaylee GM or KGM. If they're minors, they usually go by their initials in court. They awarded Kaylee a total of $6 million. $3 million to compensate her for her damages, and $3 million in punitive damages. And the jury allocated 70% of the fault to Meta and 30% to Google, which works out to $4.2 million for Meta and $1.8 million for Google. This is the first trial of its kind to result in damages to a plaintiff regarding social media. Now, if you just heard $6 million and thought, for Meta and Google, like, that's lunch money, you're not wrong, okay? These are tiny amounts for two of the world's most valuable companies. But that's one of the reasons this case is actually fascinating. The dollars matter, but the precedent matters way more, okay? The headline is not really the money. The headline is a jury said these platforms were negligently designed and their conduct was a substantial factor in harming this young woman. And they failed to adequately warn users of the risks of using these platforms. And that is why this case has people using words like landmark case, bellwether case, and big tobacco. I'll explain everything. So today I want to take you through the whole thing. I want to tell you what happened, why it is so legally complicated, why the plaintiff's lawyer used peanut M&Ms as a prop in closing arguments, and why this verdict may matter a whole lot more than the raw number of 6 million suggests. I also want to sprinkle in some legal process education as we go, because half the reason cases like this feel kind of mysterious is that most people were never really taught how civil litigation, suing for money, actually works. Okay, so let's dive in. This case is commonly referred to as KGM versus Meta Platforms, Inc. et al. It was tried in a Los Angeles County Superior Court, and Kaylee, now 20, said that she started using YouTube at the age of 6 and Instagram at age 9, and that the design of those platforms contributed to serious mental health injuries, including things like depression, anxiety, body dysmorphia, and possibly even suicidal thoughts. Now, before we go any further, let's sort of widen the lens and talk about the public health backdrop, because this case did not land in a vacuum. The U.S. Surgeon General's advisory on social media and youth mental health stated that up to 95% of young folks ages 13 to 17 report using a social media platform, with more than a third of those saying they use social media almost constantly. And in 2023, the CDC reported that 4 in 10 U.S. high school students had persistent feelings of sadness or hopelessness. 2 in 10 seriously considered attempting suicide, and nearly 1 in 10 attempted suicide. And earlier CDC reporting found nearly 3 in 5 teen girls felt persistently sad or hopeless. And another report found that frequent social media use among high school students was associated with bullying, victimization, sadness or hopelessness, and suicide risk. Bottom line, not good. But whose fault is it, if anyone's? So back to Kaylee's case. Originally, this case involved more than just Meta and Google. TikTok and Snap, who own Snapchat, were also defendants, but both settled with Kaylee before the trial in a confidential settlement. And so the trial just proceeded against Meta and Google. And those settlement terms were not publicly disclosed, obviously. And that matters because it tells you something important right away. Even before the verdict, at least some players in this industry had apparently decided they did not want this particular plaintiff and this particular evidentiary record, all of the records and memos and testimony tried to a jury. I don't know. They may have thought, we think this jury could run away and award millions and millions and millions of dollars, or we just don't want our name in the newspapers in connection with this case. Who knows? There are millions of reasons that you decide to settle. We'll never know why they actually settled, but they did. Now, why this case? Why Kaylee? Why this one out of literally thousands of similar cases that have been filed? Why was this one chosen by the courts to get tried first? This was a bellwether trial, okay? And here's what that means. When you have a large number of similar cases, and here there are over 10,000 individual lawsuits nationwide, plus a whole lot more that have been filed by school districts and actual attorney general's offices of states against Meta and Google. The court system can't realistically try every case all at once. I mean, they can try every case, but just it's going to take a long, long time. So it selects a few representative cases to go first. And those are what we call bellwethers. The point is not that the bellwether verdict automatically decides the others. It does not. The point is that it gives everyone information. What arguments work, what evidence lands, how jurors react, where the, legal vulnerabilities might be, and what settlement values may start to look like for other cases. And that means this verdict is important not only because Kaylee won, but because thousands of lawyers, judges, insurers, plaintiffs, defense teams, legislators, and even investors were watching this one case as a signal, okay? And the signal they just got was a jury can be persuaded. Now, let's talk about what the jury actually found, because this is where the case starts to get really interesting. The jury found that Meta was negligent in designing or operating Instagram, and that Google was negligent in designing or operating YouTube. The jury also found that each company's negligence was a, quote, substantial factor in harming Kaylee, and that each company failed to adequately warn users about the dangers of using those platforms. And those are not throwaway findings. Substantial factor is causation language. It means the jury was not saying that social media was merely, part of the story. It was saying it materially contributed to the injury. And then came the damages. The jury awarded $3 million in compensatory damages and $3 million in punitive damages. In order to get punitive damages, the jury has to find, as they found here, that the companies acted with malice, oppression, or fraud, which is, again, the kind of finding that opens that door to punitive damages, at least under California law and in a lot of other states as well. The punitive split tracked the same 70-30 liability allocation as the compensatory damages. So Meta ended up paying $2.1 million in punitive damages, and YouTube or Google ended up paying $900,000. And so really, what's the difference between compensatory and punitive damages? Compensatory damages are meant to compensate. They are supposed to make the plaintiff whole, at least in theory. They cover things like emotional distress, pain and suffering, therapy costs, future harm, that sort of thing. The punitive damages are not primarily about making the plaintiff whole. They are about punishing the defendant and deterring similar conduct in the future. So in plain English, compensatory damages say, you hurt her. And punitive damages say, and what you did was bad enough that the law wants to smack the back of your head in public. This is why punitive damages are such a big deal in a case like this. Once a jury gets to punitive damages, the conversation shifts from what happened to Kaylee to what kind of corporate behavior do we want to discourage here? And that's a big shift. And let's talk about one of the trial lawyers, because juries don't decide facts in a vacuum. They decide stories told by attorneys and the people on the stand. The public face of the plaintiff's trial team was a guy named Mark Lanier. He's a Texas trial lawyer, very, very famous. A lot of us are familiar with him. A Wall Street Journal profile, as a matter of fact, published after the win, described him as, quote, a seasoned Texas trial lawyer and a part-time pastor known for folksy but highly strategic courtroom storytelling. So, and that pretty much describes him. Okay, the LA Times reported that during the punitive phase, Lanier used a glass jar filled with 415 peanut M&Ms to represent Alphabet's, or Google's, $415 billion in stockholder equity at one point in time. Apparently, during the punitive damages discussion, Lanier asked the jury, so what are you going to fine them for this? And then took a tiny bite of a peanut M&M and said, that represents $200 million of their profits. That is so classic plaintiff's lawyer. The message was, if you want to punish and deter a giant company, a few $1,000,000 can just become a rounding error unless jurors consciously think about scale, right? And frankly, that is trial lawyer theater at its best. It takes an abstract concept, corporate wealth, deterrence, proportionality, and turns it into something jurors can hold in their minds, right, and see. And because of Alphabet and Meta are bringing in enormous revenues, then a verdict has to be understood in context. A punitive award that sounds large to a normal person may be functionally teeny to $1 trillion company, right? Now, who testified? Kaylee herself testified. And that matters because juries often decide these cases not just on, spreadsheets and expert reports and depositions and stuff, but on whether the human being in front of them is credible, sympathetic, and able to sort of describe a before and after story that feels real and believable. She said she became addicted to these platforms at a very young age and tied that use to her mental health struggles. And when her therapist was on the stand, the therapist acknowledged that social media was not all bad for Kaylee, that she liked making online art, which is actually important because it made the plaintiff's case more nuanced and believable, right? And the jury also heard from high-level Meta leadership, including Mark Zuckerberg himself and Adam Mosseri, the head of Instagram. That is extraordinary, actually, and strategic. Why would Zuckerberg testify personally in court in this matter? Because in a case like this, the plaintiff is not merely accusing, low-level engineers of making bad choices in design. The plaintiff is saying the company itself made profit over safety decisions. When internal emails and policy debates are going to be shown to a jury, there comes a point where the company may decide it is better to put the founder or a top executive on the stand to explain those decisions rather than let, documents speak for themselves or low-level people do the talking who can't really explain the corporate strategy. So it's a credibility move, a control the narrative move, and oftentimes a damages control move as well. And jurors saw internal documents about how Meta and Google sought to actively attract younger users, and Zuckerberg testified about Meta's decision to lift a temporary ban on beauty filters, despite internal warnings that the filters could be harmful to teen girls. His explanation was that he didn't think the evidence was clear enough to justify limiting people's expression on the platform. And that helped develop a really revealing defense theme: speech, user choice, and uncertainty, rather than outright denial that these issues exist. They may be happening, but it's just too tenuous of a connection to tie those outcomes to our platform, is a large part of their defense. And Mosseri, Instagram's testimony, fit the same pattern. He defended Instagram's choices around features that some insiders considered harmful, including disputes over whether to keep bans on the filters that mimicked plastic surgery. Internal emails shown in court included warnings from inside Meta that lifting the ban could make the company look like it was putting growth over responsibility. And Mosseri testified that he was trying to balance multiple concerns and that product and policy decisions evolve over time, that it's complex, it's complicated. He described a constant trade-off between safety and the right to free speech of people who are posting stuff on the platform. So why is this all so interesting? Because it shows you what this case was really about, not simply whether sad things happen online. Everyone agrees that things happen online that are sad, okay? The question was whether these companies made deliberate design choices, infinite scroll, autoplay of videos, notifications out the wazoo to keep you engaged, and visual features tied to appearance, all that were engineered to maximize engagement in ways that predictably harmed children and teens. Okay, this brings us to the heart of a very important legal issue in cases like this. Section 230. Section 230 is part of the Communications Decency Act. Okay, that was a federal law that was enacted in 1996, and it generally protects online platforms from being treated as the publisher or the speaker of user-generated content. Okay? Very often, if you sue a platform over something that appeared on the platform, Section 230 is the first giant wall that you run into. We're just a platform, not the creator of the content, so you can't sue us. So, and it's super effective. It has been effective in the past. So how did Kaylee get around that wall here? By changing the target, okay? Instead of saying, you are liable because users posted harmful material that then impacted me in a negative way, Kaylee's team said, in essence, you are liable because of how you designed and operated the product itself. Very different, right? They got around the Section 230 problem by focusing on the design decisions rather than just on the third-party content. And that shift is enormous. It's the difference between, say, suing a bookstore because someone bought a bad book there that they didn't like, and suing the manufacturer of a slot machine because the machine itself was built to exploit human vulnerabilities, right? The plaintiffs here wanted the jury to see Instagram and YouTube as the slot machine. They created a legal theory in product design terms, and the jury found the companies knowingly designed their platforms to addict young users without adequate concern for their well-being. That is why people keep invoking big tobacco as a possible roadmap going forward for these types of cases. I'm dating myself by talking about big tobacco, but some of you may remember that big tobacco litigation eventually became powerful, not because smokers proved every cigarette instantly harmed every person in the exact same way. No, it became powerful because plaintiffs and governments amassed evidence that tobacco companies knew about addiction, and they manipulated product design, and they downplayed risk and marketed aggressively to people, including youngsters, anyway. And once the internal documents started coming out, the moral center of those cases shifted, right? The fight was no longer just about individual choice. It became about whether a giant industry had engineered dependence and then, on top of it, concealed the danger. And admittedly, this social media litigation is not identical. Cigarettes involve a physical substance that hurt people. Social media also provides some benefits that smoking does not. Connection, creativity, community, even education like this. And so causation is murkier, right? Your home environment matters big time. Mental health is super complex, and not every child who uses social media gets hurt. This is all true. But if plaintiffs can prove that these companies understood how specific design features affected developing brains, knew that some subsets of children were, particularly vulnerable, and continued prioritizing engagement and growth over safety, then you can see exactly why the tobacco analogy has some traction, right? to be fair, the defense had real arguments as well, which made this, not easy on the jury, I'm sure. Meta argued that Kaylee's mental health struggles were caused by her difficult home life, not by Instagram, and that Instagram was what provided a creative outlet for her even. And Google's line was a little bit different in that it argued that Kaylee's usage of YouTube was minimal and pushed back on whether YouTube could even be treated as a social media platform in the same way as Instagram. First, they argued other causes, home life. Second, they pointed out user agency and parental responsibility. It's up to the user as well. You can't just shirk your responsibility and put it all on the platform. And then they said, our product has benefits too. And then you're trying to punish us for conduct that federal law protects, the right to free speech. All of those are not frivolous arguments. In fact, they're arguments that will likely dominate the appeal. And yes, both Meta and Google have indicated that they do plan to appeal. We'll see. No appellate court has weighed in on whether these kinds of platform designs, whether these platform design claims fall outside of that Section 230 protection in a way that would bind lower courts broadly, meaning reverse them, So that's why this case matters beyond Kaylee. Trial court wins are important, yes, but appellate decisions, when things get appealed, those are what tend to shape the law for everybody else. Appellate cases are what we quote in court as authority, right? But in order to get to that appellate decision, you got to get through the trial court first. Now, let's take a little civil procedure detour, because this is one of those things that folks should really realize. Because you read these huge, settlements and giant, multi-million-dollar verdicts. But when the rubber meets the road, how does it really happen after the verdict is read and the dust settles? When a jury enters a verdict like this, it does not usually mean that a check gets written next week. Defendants who have found liable and that, ostensibly owe a bunch of money may file motions challenging the verdict. The punitive damages get challenged a lot. They may challenge after the fact the admissibility of certain evidence or how the jury instructions were crafted. There are a million ways that they can, object to the decision. Then they formally appeal. In California, where this case was heard, a money judgment is generally enforceable when entered. And also, that law imposes a 10% annual post-judgment interest on the money that's due from the date of the verdict until the date it's paid. So this kind of judgment can accrue interest while the appellate process grinds along, even though collection may itself be postponed until all the lawsuits around this case are done, whatever that looks like for this case. And that matters for at least three reasons. One, time can definitely become leverage, and interest can become leverage. And the appeal itself can become leverage. And this means that settlement can happen at any point. Before a judgment, even after a $6 million judgment, the parties can settle for a different amount while an appeal is pending. Even after oral arguments have been made in an appellate court, the parties can decide to settle on a different amount than was awarded at the lower trial court level. The verdict changes the bargaining power, certainly, but it does not necessarily end the bargaining. Now, Why on earth would a plaintiff who had won $6 million at the trial court level settle for less prior to the appeal? Answer: lots of reasons. First, appeals are risky. A good verdict can be reversed entirely or sent back to the trial court for a whole new trial. Or it can be reduced by the judge or the appellate court. And like I said before, punitive damages are especially vulnerable on appeal. Second, appeals take time. Even a strong plaintiff may not want to wait years to see any money. A bird in the hand matters, A guaranteed recovery now can be worth more than a larger theoretical recovery 3 years from now or 10 years from now. And finally, plaintiffs often have personal reasons to settle, especially in a case involving a young person and mental health. The plaintiff may simply want closure. Litigation is exhausting and all-consuming and expensive. And being the face of a landmark or bellwether case can get old really fast. Sometimes you just want to move on. This is all why lawyers pay such close attention to the bellwether outcomes. A $6 million verdict may be tiny as against Meta and Google standing alone, but it often suggests meaningful exposure across thousands of similar cases. The math changes very, very fast. Now, an interesting tidbit is, $6 million is nothing to shake a stick at, but the plaintiff, Mark Lanier, on behalf of Kaylee, asked the jury for $1 billion. So $6 million is a little different than $1 billion. And so one has to ask, are Meta and Google freaking out because this case happened and it's establishing a precedent that thousands of other cases can point to and say, see, it's okay. Other people have found, a strong enough connection to award money. Or maybe Meta and Google are like, phew, we dodged a bullet. It's only $6 million, right? Time will tell. Appeals will happen. Possibly more cases will be filed now. And so it's going to be years in the making before we really make sense of this litigation. But make no mistake, this case is exceptionally important, whatever ends up happening. So what exactly does this verdict mean going forward? For Meta and Google, it does mean risk, any which way you look at it. Not just financial risk from a $6 million verdict, but reputational risk. Meta's stock slipped after the verdict because of the broader legal exposure that does exist now. If appellate courts bless the idea that design-focused claims like this are outside of that Section 230 shield, the litigation threat expands dramatically. So again, we'll see. And it also means possible pressure to redesign stuff now. This litigation could eventually force companies to add consumer safeguards that might, hurt their growth. If the business model depends heavily on engagement time and predictive recommendations to people, and if certain design features start to look like liability magnets, then legal pressure can become pressure to redesign the product altogether. So these platforms might start looking a little different in due time. We'll see. It means that future juries are going to hear over and over that one jury already found these products negligent and inadequately warned users. And yeah, each case is different, make no mistake. And no verdict is binding across unrelated plaintiffs. But culturally, the wall has now cracked, right? And for families and ordinary users, the meaning, I think, is more complicated. This verdict does not mean that every teenager with depression has a lawsuit, right? It does not mean that parents are off the hook for supervising their kids' use of these platforms. And it certainly doesn't mean that social media is the legal equivalent to cigarettes. But what it does mean is that courts and juries are becoming more open to the idea that social media companies may owe duties based on how they design products for young people. That has become clear. It means the legal system is beginning to treat youth mental health harms from platform design as something potentially actionable, not just unfortunate anymore. It means parents and schools and lawmakers and companies are now operating in a world where that's just the internet is becoming a less sufficient answer. This case forces a cultural reckoning around a question we've been avoiding for years. At what point does optimization become exploitation? When a company studies attention, reward loops, beauty filters, notifications, and compulsive use patterns, at what point is it no longer merely making a successful product and instead engineering dependency, which is not cool? Before I sign off, I want to circle back to one of the most important reasons this case landed the way it did. It was not just the science. It was not just the documents. It was not just Mark Lanier's M&Ms. It was the legal framing. This case succeeded, at least for now, because the plaintiff's team found a way to tell the jury, do not get lost in content moderation. Do not get lost in whether one comment or one video caused one bad day. Look at the machine. Look at what it was built to do. Look at what it was built to capture. And look at what the companies knew. That is a very different conversation than most internet liability cases have historically allowed legally. Again, because of Section 230. And that is why this may end up being remembered as a turning point. Not because Kaylee became fabulously wealthy. She didn't. Not because Meta and Google are finished. They certainly are not. And not because this settles a legal issue. It doesn't. But because a jury in a real courtroom, after hearing from real executives and seeing real internal documents said out loud, we are willing to hold social media design legally responsible for mental health harm to a minor. That is new. And once a thing becomes imaginable in law, it becomes a lot more possible again and again and again. So the next things to watch are these. Watch the appeal. Watch how aggressively Meta and Google push Section 230 and First Amendment arguments. Watch whether any settlements start happening during the appellate process. And watch the next bellwether trials that are queued up in California. And there's an upcoming federal proceeding in Oakland that you're going to start hearing about, I guarantee you. Senators have already pointed to this verdict in calls for federal legislation requiring platforms to design with kids' safety in mind. So they're saying, let's take it out of the court's hands and enact some laws that these companies have to live by. And if you're a parent, a teacher, a policymaker, a platform designer, or honestly just a human being trying to understand what the internet has become, that is why you should care here. The law has finally started asking questions many families have been asking for years. Not just whether children are suffering online. They are. but whether someone should be legally responsible for building systems that make that suffering more likely. And in Los Angeles, one jury just answered yes to that question. So thanks for being here. I'll see you next time.